Hi, I am Carmela Katapang from BSMA 2103. And now, I want to share some articles and obligations and contracts under the new Civil Code of the Philippines. So, let's start on Article 1160. It deals with quasi-contractual obligations. Quasi-contract is a juridical relation resulting from lawful, voluntary, and unilateral acts which are enforceable to the end that no one shall be unjustly enriched or benefited at the expense of another. So, quasi-contract, it is not properly contract at all because in contract, there is a meeting of the mind between parties, while in this quasi-contract, there is no consent as the same supplied by law. Quasi means semi, so quasi-contract is a semi-contract. This quasi-contract is created by court to avoid unjust enrichment of a party in a dispute over a payment for a goods or services. It has two kinds. First is solutio indebiti, and second is negotiorum gestio. When we say solutio indebiti, it refers to payment by mistake, which you are required to return the money through mistake. For an example, Leia went to Arat Burger to buy some burgers and price worth 170 pesos only. Leia gave a 200 to the vendor and received a change of 80. So Leia is duty to bound to return the excess of 30 to the vendor, or else she will be unjustly enriching herself at the expense of the Arat Burger. Even though no contract exists between them, under quasi-contract as a source of obligation, you are bound to return what is paid by mistake. Avoid unjust enrichment. Second is negotiorum gestio. It refers to management of another's property. For an example, Adrian, a wealthy landowner, suddenly left for Cebu to visit her grandmother for 1 week. Joshua, a neighbor of Adrian, managed the land without knowing or consent of Adrian, so thereby incurring expenses of Joshua. When Adrian returns, he has the obligation to reimburse Joshua for the expenses incurred by him. It is based on the principle that no one shall be enriched at the expense of another. So I'm done discussing Article 1160, and now I am proceed to discuss Article 1165 of the new Civil Code. Article 1165 talks about remedies of creditor in real obligation, whether it's generic or specific. We all know that in our previous discussion, specific thing or determinate thing is cannot substitute it with another without the consent of the creditor. So in an obligation to deliver determinate thing, the very thing itself must be delivered because this thing is very unique and specific. So as it turns out, when a debtor does not fulfill his obligation to deliver a determinate thing, the creditor may exercise some following options or actions. First of which is to demand specific performance or fulfillment of the obligation with a right to indemnity for damages. So if the debtor does not deliver the specific thing, creditor may complain or demand specific performance. Second, demand rescission or cancellation with damages. So there's a case of or time that the debtor cannot really longer to be delivered for whatever reason. So as a creditor, he has a right to demand for rescission or cancellation with damages. Third, if it is only feasible remedy, demand payment damages from the debtor. So I giving you an example. Junior contracted to deliver a specific SUV car with a plate number XYZ1234221 on December 23. Here comes December 23, Junior failed to deliver the SUV on the stipulated period for whatever reason. So on this case, Juan can compel Junior to deliver the said specific SUV car because there is no other person in possession of that wonderful thing. Juan can also demand payment of damages from Junior. However, if the case is Juan paid 20,000 to Junior before the delivery and Junior was not able to deliver a specific car, Juan may elect of one remedy, which is rescission or cancellation, in which case Junior must return the money with damages. So, these remedies are alternative, not cumulative, meaning you cannot avail all the remedies at the same time, one at a time. So, I'm done discussing the remedies of creditor in specific real obligations. So, now I'm going to discuss the rights of creditor and generic real obligation to deliver a generic thing. If a debtor does not fulfill his obligation, the only remedy that the creditor may exercise is to ask a third person to fulfill the obligation at the expense of the original debtor. So, for an example, Ino is obliged to give Inday 50 sacks of rice. If Ino does not deliver the said rice on due date upon Inday's demand, Inday can obtain rice from other sources at the expense of Ino. Since rice is a generic thing, Inday can obtain from other sources because it can be replaced with same quality. Inday can also ask for damages. So in this case, there is no specific performance because it is generic real obligation. Now, we go to Article 1167 and let's see what the codal provisions provided. Article 1167 talks about an obligation to do wherein positive personal obligation. It requires the debtor to do something, an act, or render service. It is important for us to know the situation contemplates under Article 1167. First, when the debtor fails to perform an obligation to do. On this situation, the debtor absolutely fails to do the obligation. Second, when the debtor fails to perform his obligation but contrary to the terms thereof. It means on this situation, the debtor did something but the obligation he performed is not stipulated by the parties. Third, if the debtor performs an obligation to do but in a poor manner. So, in this case, the debtor did something but it was poorly done. In this case, what are the remedies of the creditor? First, if the creditor fails to comply with his obligation to do, the creditor has the right to perform the obligation by himself or by another unless personal considerations are involved at the debtor's expense and to recover damages. So, for an example, Kiray celebrating her birthday on this Friday. She wants to sing Sarah Geronimo for intermission number, but Sarah refused to sing because she has many activities to do, but she sent another singer for replacement. On this case, Sarah cannot send replacement since her voice is not the same with the same replacement. In addition, Kiray cannot force Sarah but she can hire another singer at the expense of Sarah or rather ask for damages. So, here, the personal qualification of Sarah is the determining motive for the contract. So, in this case, the only practical remedy is indemnification for damages. If you notice, Article 1167, there is a remedy on the part creditor to let the obligation performed by a third person. So, now let's go to Article 1174. This is the last part of our discussion. Article 1174 talks about fortuitous event. When we say fortuitous event, it is an event which cannot be foreseen or impossible to avoid. The general rule, the person is not liable for loss or damage, but it has exception. First, when it expressly specified by law, the debtor is guilty of fraud, negligence, or delay or contravention of the tenor of the obligation. So, for an example, Jaser is obliged to deliver a specific dog to Regine on December 25. Jaser did not deliver the dog on said date. If on December 26 the dog died because it was hit by a car, Jaser is not liable if no demand was made by Regine. If the dog died after a demand was made by Regine, Jaser is liable for damages because he is guilty of legal delay. In this case, the obligation of Jaser to deliver the dog is also extinguished, but it is converted into monetary obligation to pay damages. So, thank you for watching!